Welcome to you. I am Lőrik József Balázs, a defense attorney from Budapest, Hungary. In this video, I will summarize the most important informations what you may need if a criminal procedure is initiated against your relative, possibly he or she is in custody or under arrest. For most people, becoming involved in a criminal procedure is a single but at least a very rarely occurring situation in life. In addition, a criminal procedure often goes together with coercive measures. The most serious coercive measures are custody and pretrial detention. Being under custody or arrest results depressing and overwhelming feelings. In such a situation, being aware of the rights they are entitled to and of the obligations they bear in a criminal procedure. One of everyone's favorite rights are freedom of movement and residence. These rights are constitutionally guaranteed under the fundamental law of Hungary. These rights can be restricted in a criminal procedure if all other conditions are met. Arresting a person means that he is deprived by a court of his personal freedom before a final and binding conclusive decision is passed. There are currently 4,000 people in Hungarian prisons under arrest. If criminal procedure is initiated against your relative and you would like to be aware of the rights and the obligations of the defendant in connection with coercive measures, watch this video. If you would like to ask the advice of a professional, contact us and make an appointment for consultation. What does custody mean in Hungarian criminal procedure? Custody is a temporary deprivation of a defendant from his personal freedom. If there's a reasonable suspicion that a criminal offense punishable by imprisonment was committed, custody may last until the court's decision about the arrest or other coercive measure affecting personal freedom, but it may not exceed 72 hours. Within this period of time, the lawyer has to collect all those documents which we will need at pretrial to convince the court that it's not necessary to arrest the defendant. Such documents, for example, proof of income, documents in connection with the defendant's personal circumstances, residence employer's certificate. What is pretrial detention? Pretrial detention or arrest is not a preliminary punishment, but a coercive measure which, taking into account the principles of legality, proportionality, and gradation, the court may apply only to achieve the goal defined by the law, if the use of a milder coercive measure to achieve the goal doesn't lead to result. In this video, I will talk about the reasons and the procedural rules for arresting someone in Hungary. What are the general conditions of pretrial detention? Pretrial detention can be ordered in a criminal procedure for a crime punishable by imprisonment. The Hungarian Criminal Code consists of a few crimes which are not punishable by imprisonment, like violation of privacy, violation of correspondence. Therefore, if the criminal procedure is underway for the above crimes, there is no place for pretrial detention. Reasonable suspicion is, on the other hand, the well-founded suspicion that a crime has occurred and, on the other hand, that the crime was committed by the suspect. A suspicion is established if there's a greater than 50% probability that crime has occurred and that the suspect committed it. On the other hand, reasonableness also means that there's evidence that serves as a basis for suspicion. If there is no credit-defying evidence from which the above could be inferred, or if the available evidence was obtained illegally, reasonable suspicion cannot be established. The reasonable suspicion must be communicated to the suspect. The more the criminal proceedings progress, the more the strength of the suspicion must be investigated. The fact of indictment replaces the existence of well-founded suspicion. When examining this third general condition, the court must take into account the nature of the crime, the status and interests of the investigation, the personal and family circumstances of the accused, the relationship between accused and the person participating in the criminal proceedings or another person, and the behavior of the accused before and during the criminal proceedings. After a thorough examination of the above circumstances, the court may find itself in the position of being able to take a well-founded position of the question of whether the goal so to be achieved by the arrest can be ensured by a milder coercive measure like restraint or criminal supervision. What are the purposes and special conditions of pretrial detention? To arrest the defendant in order to achieve the following three objectives: ensuring the presence of the defendant, preventing proof being made more difficult or being legally influenced. It may take place in order to prevent the possibility of reoffending. Before issuing the decision, the investigating judge hears the defendant in the presence of the prosecutor. The court, the prosecutor's office, and the investigative authority must strive to ensure that the arrest lasts as short as possible. How long can pretrial detention last? It depends on the seriousness of the crime being prosecuted. If the crime for which the proceedings are ongoing is not more serious than 3 years imprisonment, then for 1 year. If it's not more serious than 5 years imprisonment, then for 2 years. If it's not more serious than 10 years imprisonment, then for 3 years. And if it's more serious than 10 years, then for 4 years arrest. Execution of the arrest. Before the indictment, the investigating authority or the prosecutor's office, and after the indictment has been filed, the court, in the case of ordering the arrest of the accused, shall immediately notify the adult indicated by the defendant about the order of arrest and the place of the arrest as well. If a criminal procedure is initiated against you or your relative and you would like to ask the advice of a professional, contact us and make an appointment for consultation. Thanks for watching. Goodbye.